Struggling to pay your child support? Are not receiving any? Need a modification? Has the Department of Revenue filed a case against you? Don't face this alone. If you are dealing with a child support problem, a knowledgeable family law attorney may be able to help you solve it. Let us help so you can focus on being the best parent you can be. Stress less, choose more. Good afternoon, everyone. My name is Conti Smith, and I'm here with Paul Shafranski. And this is part 3 of Common Mistakes, Complex Cases, and What Happened Next. So, Paul, do you want to introduce yourself to our viewers?
Sure. Hi, everybody. My name is Paul Shafranski. I am a lawyer at Artemis Family Law Group, and I specialize in a few areas, one of them being appeals, particularly appeals in family law matters. And that's what I'm here to talk about.
Awesome. And so Paul is our go-to referral source for appellate work. He's amazing. He's brilliant. And so we're thrilled to have him on our show again for part 3. So are we ready to get into it, Paul?
I am ready.
Okay. So let's get to the first question. I agreed to a settlement under pressure in court, and now I regret it. Can I appeal the agreement?
Probably not. Appealing agreements are very difficult because it's not that the judge made a decision weighing evidence or deciding a contested matter. You put in writing or on the record that you both were agreeing to the outcome instead. And courts tend to view those agreements through standard contractual rules as if it were any other type of contract. And so that means you have to look at it from a contractual standpoint, which means your only real grounds to overturn or set aside an agreement is, fraud, duress, undue influence, material misrepresentation of fact, very specific things. It's not, I changed my mind, I thought about it the next day, I wanted to talk to my attorney more. You got to speak up. And if you need time to think about something, then you need to take that time to think about it. It's really difficult to get an agreement set aside. And you also need to try to get that set aside first with the trial court. You don't directly appeal that because the appellate court's just going to see you signed an agreement and it sounds like you've just changed your mind. Well, that's not good enough.
And that happens a lot sometimes, even in mediation, where people are like, oh, the next day, I don't want to agree to that anymore.
Yep. And that's why you've got to take your time. And at the end of that mediation, if you haven't signed that document yet, it's up to you to say, I want some extra time to think about it. I need a day, whatever. It's your life, it's your agreement, and it's your signature going on it. So even if everybody's telling you this is your last chance, I always say, if it's a good deal on Monday, it'll be a good deal on Tuesday.
No, agreed. All right. My ex violated discovery rules and hid financial documents during the divorce. What are my options after judgment?
After judgment, you can file a motion to set aside the final judgment for certain specific grounds, including a material misrepresentation of fact, failure to disclose evidence, violating discovery rules. Those are things that you can bring to the trial court's attention. You must bring it to the trial court's attention first. Number one, it's not an appeal originally. It needs to be brought to the trial court's attention first. And there are also very specific deadlines and time constraints on that motion to set aside the final judgment. You can't wait too long to do that. It's usually longer than a notice of appeal, but it's still not forever. You can't wait 5 years and then bring it to the court's attention. You have to bring it to the court's attention pretty much immediately. And it also has to be evidence that would have actually had an impact on the outcome, right? It's not just, oh, well, he didn't tell me about that bank account that has $12 in it. Well,
right.
It's probably not going to change anything. But if it's, a $12 million bank account, yeah, bring that to the court's attention for sure. But you do that first before you appeal it. But you definitely want to do that. If you do it in the wrong order, you may end up missing out on your appellate rights.
Right. Okay. The judge changed our temporary custody arrangement at the final hearing without warning. Is that allowed?
Yes. So technically, if they did that without warning, that was because your attorney didn't tell you that that was potentially an outcome. Because if it's a temporary custody arrangement and you're going to a final hearing now, the very idea is it was temporary in nature to begin with, and it is subject to the court making a final decision as to that arrangement at a final hearing. Meaning the court could say, sounds like it's been working out well, so I'm going to keep it as is. Or the court could say, no, you've moved 30 miles since I entered that temporary custody arrangement in. That's not going to work anymore. Or the court could say, the communication is so fraught between the parents that they can't exercise time sharing with this many exchanges, so I'm going to change it. So the court absolutely can, and it's their job to look at the final time sharing arrangement and make a decision based on all of the facts at that point, because at a temporary hearing, you usually have minimal information and the court's making quick decisions with little information on a temporary basis. The final hearing is where you get the full evidence out there, and the court may have a different take on it based on all of the evidence that's presented. So it not only is allowed, it's what the judges are supposed to do.
Yeah. And that's I know, at least from my practice, I see it a lot where even with child support, people think that they can agree to a child support amount and you can't, or they try to waive it. Like they say, oh, we're going to waive it. Is it pursuant to the guidelines? And so people, the court ultimately has final say over the child support, over the time sharing. You can't put those things in a prenuptial agreement as it relates to, I'm going to waive this, or this is what the time sharing will be. The court has to do what's in the best interest of the child. And so that's
always, no matter what else you all have done in the past or what arrangement you made privately or temporarily, the court has a best interest standard that it has to adhere to no matter what the parents are saying.
No, absolutely. Okay. I never received notice of one of the hearings and a decision was made without me. Can I appeal?
You can certainly seek to have that decision either set aside or revised or bring it to the court's attention, because you are supposed to have notice of hearings. There's a due process component. Now, is the issue that you were never notified at all? The court just set this hearing and maybe didn't realize that it didn't do it properly or something? Or is it that your attorney didn't tell you about it? Because if your attorney didn't tell you about it, you got notice legally, probably, and you now have an issue with your attorney and not necessarily with the court. But if, let's just say you truly were not notified, there was some glitch in the system and you were not notified of a hearing and the court proceeded without you, there's at least a good chance of being able to, as long as the court believes you, to convince the court that there was a due process violation, because you are supposed to be provided notice of any hearing where the court needs to hear from you and is making a decision that's going to impact your case, your kids, any of that stuff. So it's very fact dependent, but you are supposed to get notice of a hearing before the court can proceed.
Nope, I agree. The court ordered supervised visitation based only on allegations, not proof. Can that decision be reviewed?
Yes. So evidentiary rulings that are based on the court's hearing and weighing of evidence and making credibility determinations of witnesses can definitely be reviewed on appeal. That's kind of one of the classic appellate issues is, was the decision that the court made supported by competent substantial evidence, or whatever the evidentiary standard is for that issue? Did the court, was there evidence to support that? That said, one person's allegations is another person's proof. So you may think it was only allegations, but the court may have viewed it as proof or seen it differently. So what a lot of times what happens in these situations is the court does end up weighing two conflicting pieces of testimony from opposing parties, and the court will have to ultimately kind of weigh that evidence, make a credibility determination, and decide who it believed and who it didn't believe, or who it found more credible. So that doesn't necessarily make it just an allegation. That could be enough proof to support the ruling. But certainly evidentiary decisions are appealable, and the trial court can't just go do this stuff on a whim. There does need to be competent, substantial evidence to support the rulings that the court makes under any of the issues.
Yeah. Okay. I'm representing myself, and I think the judge held me to a different standard than my ex's attorney. Is that appealable?
Yes, but it's a real tough one. So if you're representing yourself, there's ample case law that says you are held to the same standard as someone who is represented by counsel. You're not held to a lower standard. The court doesn't do special favors, doesn't spoon feed you information, or it's not supposed to. It doesn't say, oh, well, you know, she was representing herself, so let's cut her a break in the ruling. That's not how it's supposed to work. But you're also not held to a higher standard. You're not supposed to, it's not supposed to be tougher for you because you're representing yourself based on the rule, the standard that the court's holding you to. All that said, it's very difficult to actually prove that you were held to a different standard. That's essentially bias, kind of, that you're arguing. Mm-hmm. That can be grounds for an appeal, but you're going to need this judge on the record to really make some real over-the-top rulings or announcements or decisions or off-the-cuff remarks in order to really prove that bias. It's going to not just be unfavorable rulings. People that are represented by counsel get unfavorable rulings all the time. That's not enough.
Okay. All right. The judge denied my request to relocate with my child, even though I had a job offer out of state. What can I do next?
You certainly can appeal a denial of a petition to relocate, but those are tough ones to win on at the trial level, and they're even tougher to win on at the appellate level. So, and having a job offer out of state, that's kind of, in my opinion,
one factor.
Yeah, it's one factor, but that's sort of the one that people typically, that's usually the impetus for the move or the attempt to relocate is, well, I got this great job opportunity in Massachusetts. And you know, we're in Florida otherwise, you know, people don't typically just want to relocate out of the blue. There's usually a job offer at stake, and that's not a silver bullet standard. Well, if I prove to the court that I had this really, really lucrative job or this amazing opportunity, that could maybe be enough depending on the other factors, but it's not some super factor. So you can appeal it. You certainly can appeal that denial, but it's going to be very fact intensive, and I would be cautious of anybody that's trying to immediately talk you into appealing that and telling you that it's a slam dunk or anything like that, because relocations are very difficult to win on, and they're even tougher to win on at the appellate level because the trial court's ruling will have the presumption of correctness already. So it's a real uphill battle to win a relocation on appeal, but it can be done. But just proceed with caution.
All right. My divorce decree has conflicting terms that makes it impossible to follow. Can an appellate court step in?
Yes, an appellate court can step in and fix a final judgment that has conflicting terms. This happens more often than people realize, at least in my experience. So, but what you really should do is file a motion for rehearing, a timely motion for rehearing with the trial court, bringing it to the trial court's attention and saying, hey, on page 3, you said I get sole parental responsibility, but on page 7, you said shared parental responsibility. Which one is it? You really need to bring that to the trial court's attention first to fix. The appellate court does not want to go in and try to address inconsistencies like that if they haven't been addressed with the trial court first, because they theoretically should have known what they meant to rule and can fix it a lot faster than an appellate court. But if the rehearing is denied, the trial judge just says, oh yeah, sure, I did say A on this and B on that, but I don't care, and they deny it, or they just weren't paying attention, or for whatever reason they deny your motion for rehearing, you can absolutely appeal it, and you should, because if you don't have clarity, then you don't know what the rules and expectations are going forward. You don't know if you're accidentally in contempt of court for not following the rules of the final judgment. So yes, you definitely should get the appellate court to step in if the motion for rehearing is not doesn't correct it.
All right. The court imputed income to me even though I lost my job. Can I challenge that ruling?
Very fact-intensive question. So yes, you can challenge that ruling. Again, this is another evidentiary type of ruling. It's going to depend on what evidence the court was presented. But you can have kind of the whole idea of imputation of income is when somebody is underemployed or unemployed. So if you lose your job, you know, you might be saying, I lost my job, I had no say over it. The court may, and there may be other evidence that maybe you did some stuff that caused you to be fired or terminated with cause, or you deliberately stepped back in your role, or you asked for a part-time position. And there's a lot of reasons why people's jobs can change. But if the court thought that it was because you were deliberately trying to be underemployed or unemployed, during this process so that your income could look lower, then the court absolutely can impute income to you. It's not just because you lost your job, you get a big zero on your income for child support purposes and alimony purposes. The court will have to look at the entire scheme and say, yeah, you lost your job a month ago, but you've been employed for 30 years as an executive at whatever big company. You are very employable and you'll probably find a job very, very quickly. I'm not going to give you a zero for your income. That's not an unreasonable ruling usually. But there does need to be evidence to support that. It can't just be the court saying it based on a hunch. There needs to be a lot of discussion, evidence, history of their job, that field, what they would make in that field, that type of stuff.
Okay. The judge refused to continue the hearing even after my medical emergency. Is that grounds for appeal? That's a good question.
Yeah, and it could be. It could be. The courts have a lot of leeway in terms of running their court and granting continuances, things of that nature. But if you have a genuine medical emergency that prevents you from, you're on a gurney at the hospital about to go under, anesthesia for surgery 5 minutes before your hearing, and you have proof of that, you should be able to go to the court and say later on, ask the court to rehear or readdress their ruling. Unless it's a final ruling, the court can always go back and make changes and bring this to the court's attention and have them kind of undo what they did or give a redo, a new hearing or something of that nature. If the court denies it, let's say it's your final hearing, then that's absolutely grounds for appeal. It's fact intensive, right? It's you need to have something in the evidence to show that you actually were having a medical emergency. If you have nothing in the record to show that except a motion saying I had a medical emergency, there's no affidavit attached, no medical records of any kind, nothing to prove it. And all you're doing is saying to the appellate court for the first time, okay, but the reason I wasn't there was because I had a medical emergency, I swear, that's not going to be enough. So you've got to work that record. You've got to get evidence in, or at least attach it to a motion or something. So there's something for the appellate court to look at and say, oh yeah, there was a genuine medical emergency, or at least the appearance of one. So, this should have been granted, or this should have been set aside. But it's again, fact intensive. The appellate court makes no new factual determinations or hears no new evidence. So you got to tee it all up and bring it to them, ready to show them exactly where in the record there's proof of what you're alleging occurred.
Yeah. Okay. My ex introduced surprise evidence at trial, and I had no time to respond. Can that affect the outcome on appeal?
Yes. In Florida, we're not supposed to do what's called trial by ambush. There are rules that you're supposed to disclose your witnesses that you're going to call, the evidence and exhibits that you're going to rely on. It's not a guessing game going into a trial. Both sides should know exactly what is going to be introduced as evidence or what people are going to be introduced as witnesses. Now, that doesn't mean you know what they're going to testify to. That doesn't count as trial by ambush necessarily. But in general, you're supposed to know ahead of time what the evidence is going to be. So if somebody introduces brand new evidence, a document or a witness that was not disclosed, and you've timely objected to that and the court overrules it, then that's probably decent grounds for an appeal, depending on what that testimony actually turned out to be or what that evidence is. If it's a duplicative piece of evidence or cumulative evidence, let's say, that just kind of proves something that was already, there's like 10 other pieces of evidence proving it. It's not like some silver bullet slam dunk piece of evidence that came out of nowhere. Then it may not be it may be appealable, but it may not affect the outcome. And the court may still ultimately say, yeah, the court shouldn't have done that, but we're not going to reverse it because there was still all this other evidence that the court relied on. And also you must timely object to all this stuff. So if you sit there stunned at this new evidence, or your attorney does, and they don't object at the hearing, then you definitely can't bring that up on appeal, because you've got to object timely at the time that the evidence is being introduced.
All right. And the appellate process sounds expensive and overwhelming. Is it even worth appealing a family law case in Florida?
Good question. That's kind of the question in my world, right? And the short answer is a bad result does not make a good appeal. So just because you don't like the outcome, and just because the court made some decisions that were questionable, doesn't necessarily mean you have a good appeal, that your chances of appeal are strong. And on top of that, even if you do have a good appeal and your chances of success are pretty strong, what is that realistically going to look like for you from a cost benefit standpoint? Let's say you win on the appeal and it's sent back to the trial court, and the trial court, because it's now a year and a half later, has to do a new trial entirely. And you've sunk tons of money into your appellate counsel, because we're not cheap. And then you've sunk tons of money into a trial attorney again, because trial attorneys aren't cheap. And then the outcome, and then you get, what do you get from there, right? You still just get a new trial. What's your best day in court look like? Is that best day in court worth dragging this out for another 2 years and spending $40,000, $50,000 more? So even if you have a slam dunk appeal, if the answer is no on the cost benefit question, if we're talking about an issue that was $7,000 worth of an asset or something, a valuation question that's $7,000 at a difference, that's probably not going to be worth it. Even though you could win the appeal easily, it still will take time and money and keep this dragging on forever. So that's a very complicated question that has a lot of facets to it. That's why it's important to have at least a good appellate consultation when you're deciding whether or not to pursue an appeal, because the question isn't just, do I have grounds for an appeal? That's the first question for sure, because if you don't, then there's no point in talking about the cost benefit. But if you do have good grounds for an appeal, what's this really going to do for you financially and legally in the long run? You could potentially send it back to a trial, a new trial, and get an even worse outcome. And the court at that point does everything perfectly, not a single procedural mistake whatsoever. Well, now you have a worse outcome that you paid $50,000 for. Like, that's terrible. And you should know that going into the process, that that's a potential outcome in some of these cases. There's no guaranteed fix to some of these issues depending on the issues.
Yeah. All right. Well, thank you, Paul. That was helpful. How can people reach out to you if they have questions about appeals in Florida?
Sure. They can call me at 407-734-2914. They can go to my website, artemisfamilylaw.com, and click on schedule a consultation. They can click on the appeals page and kind of read more about appeals. Some of the videos that we've done on here are also up there as well for people to see if they missed the first couple of questions and answers that we did. But they can definitely just do a phone call or go to the website to reach out to me. I'm pretty available.
Awesome. And if anyone has any family law questions, please reach out to our firm, Conti Law. You can reach us at 407-831-0203. Paul, thank you for joining us and for answering these questions. For our viewers, you are an amazing appellate attorney, and I recommend anyone that has any questions to absolutely give him a call. So thank you all for joining us, and have a great rest of your week.
Bye.
Bye.